Um, Religion and the workplace. And the key speaker, one of the first key speaker is Brett Strauss. Where is he?
Yeah,
Please, 20 minutes, and then followed by J.S. Patil, Vice Chancellor, National Law University and Academy, Assam.
just 1 minute. Thank you.
Please, can we start?
Yes, yes,
Please.
There are people outside. If somebody can tell them that the session has started.
All right. Good afternoon, everyone. It's an honor to be with you, and thank you for those who have made it to the very end of the day. For those of us who are visitors from outside India, it's a particular pleasure to be able to comment on some of the discussions and debates that are taking place here. In this presentation, I won't presume to talk about the situation in India, but I'm going to talk about a concept that is important in jurisprudence around the world involving law and religion, and in particular in the workplace. This is the idea of reasonable accommodation. What does it mean to make a reasonable accommodation in behalf of religion? I'm going to discuss three conceptions of understanding the problem. In doing this, of course, I recognize that many situations will be hybrids, and so I'm talking about types, and many situations will actually be complex combinations or overlaps. But nevertheless, I think these are three different attitudes which are found in the jurisprudence and which are reflected in our thinking. The first is to think of an accommodation as an exception to a general and neutral rule. Oftentimes this is thought of as an unfortunate reality or a concession or a compromise that is made. But one way of thinking of an accommodation is as a special exception. The second way is to think of it as an adaptation that individuals must make to the state. We might say that a reasonable accommodation is something that the state may reasonably expect of its people, even if they are bearing some burden of acting contrary to their religious conscience. And a third conception of accommodation is what we provide to a weary traveler. This is a place of rest, a place of refuge, a place where a stranger can come and be safe and protected and sleep with their eyes closed and without being afraid for their own personal safety. So I want to talk a little bit about the implications of these three different attitudes towards accommodation. First, of course, is accommodation as an exception to general and neutral rules. From the state's perspective, this is problematic because it violates the principle of equal treatment, and it may amount to what is viewed by critics as special treatment of those who have religious needs. And so, for example, someone's special religious dietary needs, if they're accommodated, they may be given something more than what others are given, and this may be viewed as violating the equality principle. From the person seeking the accommodations perspective, they may think of this in terms of a right. They may say, I have a right to have my special needs met, and this right may be articulated in terms of the right to practice or manifest their religion. They may even claim that this right places a limitation on state power and that the state is required to give them an exception or a benefit. When we think of this as a legal issue, we're going to conceptualize this as a trade-off between the state's interest on the one hand in equality and equal treatment, and the individual's interest on the other hand in freedom or the right to exercise their religion. And typically these cases are involved by balancing interests. There are a variety of legal tests that are used. In the United States Supreme Court, the compelling state interest test is used to balance the interests of religious claimants against the interests of the state. In the European Court of Human Rights, there's the necessity test, which asks whether it's necessary for the state to impose the limitation. An example of this would be conscientious objection to military service. Someone might say that based upon their religious or other conscientious scruples, they cannot bear arms. And so the question would then be weighing, on the one hand, the state's interest in security, in the fair administration, the fair sharing of the burden of national defense, with the religious scruples on the other side. And what we've seen is that most states and most places have found ways to strike a balance that is sensible and that is quite protective of religious interests. These balances are struck somewhat differently, but in most places today, in most countries, someone who has a strong conscientious objection to military service would be given an exemption or perhaps some form of alternate service. The challenge here, of course, is to not exaggerate the value on one side of the ledger. When we're balancing, each side might want to make their interests sound extremely weighty. And so for the state, for example, to say national security, this can be equated to national survival. And that's such an important interest that it can become difficult to recognize the conscientious interests on the other side. And so there are challenges presented from thinking about accommodations in this way. In the United States, we have some examples of the difficulty that the Supreme Court has had in dealing with this type of issue. There were two cases decided in the late 1940s or in the early 1940s involving children who were Jehovah's Witnesses who were compelled to salute the flag or say the Pledge of Allegiance to the flag. In the first of these cases, which was Gobitis, the Supreme Court said there was no right to an exemption. Basically what they said is that conscientious scruples are not important enough to overcome the need of a general and neutral law. And notice how the court exaggerates the national security interest. Justice Frankfurter, writing for the majority, said, "The ultimate foundation of a free society is the binding tie of cohesive sentiment. Such a sentiment is fostered by all those agencies of the mind and spirit which may serve to gather up the traditions of a people. The flag is the symbol of our national unity, transcending all internal differences." Now, national unity, of course, in 1941 was a big issue, because the United States was really debating whether or not to become involved in World War II or not. But this interest, I would suggest, was exaggerated. Well, what happened? Well, after this case across the country, in many cities, in many places, children who were Jehovah's Witnesses were kicked out of school. There was vigilante justice, which was perpetrated against Jehovah's Witnesses. Some of their places of worship, kingdom halls, were burned down. Some of their people were beaten up. There were even places where the sheriff would arrest the Jehovah's Witnesses who were being assaulted and put them in prison, saying that they had somehow provoked violence. So instead of imprisoning the people who were beating them up, they would imprison the Jehovah's Witnesses themselves. Then the Supreme Court did something that's interesting, and which it almost never does, and that is, a mere 2 years later, they reversed themselves. And in a case with very similar facts, whether or not a state law requiring children to salute the flag was constitutional or not, the court said no. They said this violates freedom of speech and freedom of religion. Justice Jackson, this time writing for a new majority, said, "To believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds." He then said that there is a fixed star in our constitutional galaxy, which is that no official, high or petty, can dictate what is orthodox in terms of politics, nationalism, opinion, or religion. What's interesting, I think, about these two cases is they show how balancing works. We see that on the one hand, there was an exaggeration of the state's sense of security, and we see that on the other hand, in the correcting case, greater weight was given to the value of conscience and the value of liberty. Well, what's the second way of thinking about accommodation? It is to think of an accommodation as an adaptation that an individual must make to the state. And so a reasonable accommodation on this way of thinking would be an adjustment that a state can reasonably require of individuals. And the Spanish and French term of reasonable accommodation seems to suggest this understanding of what a reasonable accommodation might mean. From an individual's perspective, they may resent that it is them that is required to make the adjustment to the state rather than the other way around. And they may believe sincerely that the required adjustments violate their religious freedom or their cultural rights or their rights to freedom of expression. What they may require or desire is what we might call constitutional space, the ability to live their conscience in a way that is safe and protected. As a legal approach, the issue here becomes what we can reasonably ask of individuals to give up in the interests of equality or equal treatment or group solidarity. The question is the reasonableness of the adjustment or the burden required of individuals. And here the tendency is to think in terms of the rights and powers of the state rather than the rights of individuals. So it sort of gets backwards our normal thinking about how rights works. You'll recall the debate over the burkini that played out on French beaches this past year. That would be an example of the French government saying that the burkini, the swimwear that was very modest and covered the body and the head, was a violation of the French principle of laïcité. And it was a reasonable accommodation to require the Muslim women who wanted to be on the beach to not wear such provocative and aggressive attire. Because this would be something that would feel threatening or overly provocative to other people on the beach. Now, this argument, I think, seems silly to most of us, but that's the attitude of reasonable accommodation that the French were utilizing. It was an attitude of saying, well, it's reasonable for you to accommodate us in order to be a real French citizen. And so this is one of the implications of this mindset. In the United States, there are a number of cases playing out in the context of gay marriage that reflect this attitude. When there are examples of small businesses that have conscientious objection to participating in same-sex wedding ceremonies. These people are usually photographers or bakers or florists. And their argument is that as a matter of conscience, I don't feel I can participate in a same-sex wedding that is contrary to my religious or conscientious beliefs, and the state replies by saying, we have a rule requiring non-discrimination, and you must accommodate your beliefs to this non-discrimination norm. And so that would be an example of how this plays out. Another example is a recent case involving a Muslim prisoner with a beard. And there was a prison regulation that prohibited beards. And he had a very small beard, about 5 centimeters. And his argument was that this was required by his faith. And the state said, no, you must cut your beard because it's a danger. You might have a weapon concealed in your beard. And this is a security threat. Well, the Supreme Court rejected the state's argument by a 9-0 vote. I'm happy to report. For once, a case was easy for the Supreme Court to decide. But this was an example of the state basically telling the prisoner, you must accommodate to our needs rather than vice versa. Well, let me talk very briefly about the third conception of accommodation. And this is the one that I think is the most attractive in many ways. This is the idea that thinks of accommodation not as an unfortunate exception or not as a way in which the individual must bend to the will of the state, but rather as an accommodation as a place of shelter or protection. Here we think of a hotel or an inn or a safe place. From the